This week on Lewis on the Law, I've got another great show for you. I have attorney Francis Dixon on with me, and we're going to take a look inside the Georgia Supreme Court.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I have yet another fun-filled, exciting, and thrilling show for you. And in the name of empowering you, the listener, that's right, empowering you, the listener, we're going to take a look inside the Georgia Supreme Court today. I have attorney Francis Dixon on with me from Dixon Law, and Francis has recently tried a case in front of the Supreme Court, and that's why I've brought him on so that we can kind of take a look into this. Now, I know you just don't do Supreme Court litigation. Tell us a little bit about your practice.
So my practice is primarily focused on what we call last-minute litigation.
Generally. Oh, no! Someone's suing me and I need an attorney bad.
Yeah, or someone sued you several months ago and you weren't taking it seriously. And that's a more rampant problem in Georgia than you'd expect.
And that's a horrible mistake. Does that happen often?
You'd be surprised. And yes, it is a horrible mistake.
Yeah, I usually get these cases that have been started by another attorney who didn't know a real estate law, and they've made a complete shambles of the case. The defendant is crying in tears because, you know, she's been evicted from her own house, which is tough to do unless your attorney's completely two left feet.
Right.
Anyways, I usually get cases like that. I really don't get those cases where it's just the last second they haven't. Is it where they haven't even answered?
No. So generally, what you'll have, or at least what I'll see more frequently, is an incomplete answer. You know, there's kind of two situations that generally pull me in, and that's one, they had an attorney, and the attorney wasn't, like you were saying, familiar with the issues and familiar with what they need to do, and sort of familiar with litigation in general. Either, you know, they handle more of a transaction-based practice or litigation in sort of a pre-trial fashion. And then they found themselves now in a situation where they are deeper in discovery than they let it get away from them than they recognized. And, you know, the other side is being unreasonable with settlement. The numbers are just too far apart, and now you're set for a jury trial in 2 months, and you need to make a move.
Ouch, that sounds like a rough situation to be in. I've had similar situations happen to me.
And the other one that you'll run into is when you have a party representing themselves, right? They don't even go get an attorney. They think that they can handle it themselves, that it's a straightforward issue of just going to the court and telling them what happened, explaining themselves. And oftentimes you'll find people who, you know, don't have a bar license giving themselves a lot of credit for being reasonable and being persuasive and just completely throwing the idea that we have a court system with its own rules and aspects that they're not familiar with out the window.
That's rough. Are there lots of challenges to doing this type of thing?
There are a lot.
I mean, it seems like you'd be in a time crunch. I just have regular cases, and I feel like I am always in a panicked time crunch. I'm like, I've got to get this summary judgment motion done and written this week. I mean, how does that go?
Yeah, I mean, it's very intense. It's what keeps me engaged, keeps me invested. You know, but I couldn't do it if I didn't love it.
Okay. Do you sleep well at night? I mean, I got to ask that question because I often don't sleep well at night, and I know other attorneys don't sleep well at night. Do you sleep well at night living a life like that?
I have slept better over this last year. Certainly the first couple of years of my business, I was having a lot of restless nights, a lot of a lot of stress. You know, it's very difficult, but I've got a good head on my shoulders, I think, and I've got a good team around me, and that's the combination that really makes a difference.
Yeah, you know, you hear about it, but until you're in the middle of it, being an attorney can be a high stress job, and people don't believe it, but it's true. And people like us, we take stress for other people. I mean, usually clients who are in that kind of situation, they are unloading their stress onto us, and like, please just handle this for me.
Yeah, I just read something the other day that was talking about the merits of the attorney, right, and how, you know, we don't build jet engines or we don't do these sort of physical contributions to society, but we do. We take on and internalize the burdens of others, and we champion them in an arena that's built on adversary, right? And the stress that we have to internalize and carry with us does stack up and take its toll.
Well, about not building something, I would actually redress that one because I'm a big Charles Hamilton Houston fan. And of course, he was the one who outlined the strategy of Brown versus Board of Education, and Thurgood Marshall actually tried it. He was Thurgood Marshall's mentor. And of course, he said that attorneys can be engineers of their society. And it's true that the laws and the structures that actually guide our society are drafted by people like you and me. So about not building or not contributing, sure, there are a lot of attorneys who just kind of get fat off of the milk of the cow, but there are a lot of attorneys that are actively working to redress social grievances, redress social wrongs, and actually progress our society. So I'm not sure that we don't build things. I think we are engaged, and both you and I are lawyers for equal justice. So I mean, we are engaged in the building of a better society. I would like to believe that to be true.
I think that's an optimistic outlook, and one that I will carry with you and I'll agree with, and hope that in the long run it proves to be the case.
Did you listen to my intro? I mean,
I did. Yeah, it's a great intro.
I believe the line I'm selling, so I believe it with my soul. It's why I got into the law, because I saw how it could affect people who are ignorant of the law could still be deeply affected by the law. And I saw it firsthand. I come from a really poor background, a broken family, and I saw how people in a disadvantaged situation can just be railroaded, take advantage of all kinds of horrible things.
Absolutely. And that is, as you mentioned, the Lawyers for Equal Justice program, it's maybe a good opportunity to plug that a little bit and talk about how it really is out there trying to serve the aspect of the community that normally wouldn't be approached or have legal services available to it, right? That weird niche that doesn't quite qualify for legal aid, but certainly can't afford the market rate for other attorneys. And that's a program that, I think both you and I are proud to be a part of.
Yeah, and Francis also does a lot of pro bono work, as I do. And so I think, once again, I'm going to take issue with the fact that we don't build anything. I think people like us are building a better society. But enough of, I get on this empowering kick where I'm like, we're going to build a better world. And as long as our hearts are true and we're not just screwing people over, which I've seen attorneys do it, and it gives us all a bad name.
And it gives us more of an uphill fight when it comes to dealing with people outside of the court system, right? Certainly judges understand the picture, and other aspects of that system understand the picture. But yeah, when you're dealing with the public and you're trying to explain that you're there to help, it makes your job a lot harder when they don't trust you right off the bat.
Well, there's a lot of that. I actually saw a Facebook post, and someone showed a picture of a snake skin, and they're like, "Can anyone identify this type of snake?" And someone wrote back, "Attorney," or lawyer. And I'm just like, ouch. This is in my neighborhood too.
Ouch.
I'm just like, okay, guys, thanks a lot. There are like 3 of us in the neighborhood.
Yeah.
You've hurt all of our feelings.
Well, I had a case once where, we get done, and this guy could not have treated, it was a landlord-tenant dispute, and he couldn't have treated his, tenant any worse. And then, when he tries to basically extort this guy, at the end of the trial, we win pretty handedly. And the last thing he said to me before he left the courtroom, stored out, was, you try and help some people. So, no matter what situation you're coming from, you're telling your own story. And, us attorneys that do champion sort of the underserved and undervalued, we have to run up against that and again, stand adversarial to it. So sort of just a natural consequence, I guess.
Yeah, landlord-tenant issues are really where you see that too. You can get a good look at, because a lot of those people are really, really, literally just, they're barely making it. I mean, the conditions. I think I did a pro bono case recently where he had a rat infestation. Every time it rained, it would flood his apartment. There are roaches everywhere. The ceiling was falling down, and the landlord already had a court order demanding that they fix the property. And instead, the landlord evicted them as soon as I showed up, or attempted to evict them as soon as I showed up on the scene.
Yeah.
Wow. Yeah, it's pretty bad. That's where you really see it. Okay, we've digressed. I got into the empowering thing. You hit me with, we don't build anything, and I'm just like, okay, I got to shoot back on that. I'd like to think that we do. Okay, we contribute. Okay, so when we're appealing something, what is one of the first things that we really have to take a look at?
Well, and let's talk about where an appeal comes from, right? Because a lot of people get sort of the idea that where an appeal is sort of a second shot to basically a do-over.
You know what? We're gonna have to stop here. I didn't realize that we got into that for the whole first segment. Francis, why don't you give them some contact information for you?
Yeah. So my name is Francis Dixon, and I'm the principal at Dixon Law LLC. You can reach us at by phone 678-214-7700 or by email at Francis, Francis, at dixonlaw.com, DIXSONLAW.com.
You're listening to Lewis on the Law. My name is James Lewis. I am your host this week and every week. I have an awesome show coming your way. We're going to talk about the Supreme Court. We're going to talk about the appeals process, preserving issues, filing an appeal, the appellate brief. I always want to say appellate brief. And the oral argument. I know, apples are delicious, except for the ones that the Wicked Queen gives you.
Uh-oh.
You are listening to Lewis on the Law. My name is James Lewis, and we are reaching for higher ground right now. We are moving on up to the Supreme Court. I have a great show going for you, but before we get into this, I want to let you know if you have a serious legal issue, you can't depend on what you hear on this show. This show is only designed to give you information. If you have a serious legal issue, you need to go ahead and contract with an attorney. If you're in litigation, you can give Francis a call. If you're in real estate, if you have a real estate issue, transaction, or litigation, you can always give me a call at 404-610-0075. All my old shows are archived on my website. You can go to my website, jameslewislegal.com, and check out any of my old shows. You can also, if you have an idea for a show, you can just go ahead and hit me on my contact page. Drop me a line and tell me a little bit about what you'd like to hear, and I will bring an attorney on who actually knows something about your question, and we will talk about it on air. Okay, with that said, I want to let you guys know this podcast is nationwide. You can catch us streaming on every single major media streaming platform, so that's awesome. We are also AI compatible. Just go, "Hey Alexa, play Lewis on the Law, episode 48 with attorney Francis Dixon," and voila, this show will be streaming. So, Francis, we've got a lot of things going on here. We've got a great conversation, and we were just getting into it, and you were hitting on preserving the issue. So what do we need to know here?
Yeah, so when you talk about preserving the issue, what you're talking about is preserving errors that happen in the trial court, right? Because that's what all appeals are going to be based on. There's a misconception out there that I've run into where people think an appeal is a do-over. It's sort of a fresh start, and that's almost never the case, right? Certainly some issues can be reviewed by that standard, but for the most part, an issue has to be born out of a procedural or a legal error that occurs in the courtroom, that occurs at the trial level, right? And so that's a difficulty. That's a natural conflict there that a trial attorney has to fight with throughout any sort of litigation, right? They have to sort of keep in mind, especially if you've got a jury present, that the jury is watching. The jury is actively engaged. They're looking at it visually, and they've got that visual focus that naturally occurs because, you know, human beings are sight-based or sight-oriented creatures, versus what the product of that trial comes to, which is the record, right? You've got a stenographer in the courtroom who's recording everything and putting it into a written transcript, and so really it's sound-based, right? It's an auditory focus. And that's just sort of a natural contradiction that you have to navigate. When you talk about preserving issues, you talk about errors of perception, errors of procedure, things that crop up that you need to be mindful of both in the moment, even though the jury is going to be looking at it a different way and the jury is going to be dealing with it a different way.
And I think that is a really careful balance because you're sitting there and you don't want to be the attorney who's like, I object, and you're objecting to everything, and you realize you have to preserve some of these issues for appeal, and then all of a sudden, you might be viewed as being contentious, but some of this has to be done, so it's kind of a careful line to draw.
It is. It's a really thin line to walk because you're hit the nail on the head. If you're objecting at every potential issue just to preserve the error, you might just be forcing yourself into appeal because the jury's not going to want to be on your side. You might be alienating the jury. On the other side, if you sort of play more to the jury and care too much about them and the verdict right ahead of you, if you do end up on an appeal, you're going to have a hard time fighting for issues you didn't preserve.
And that can be really problematic, especially if you run into a contentious judge who decides that. And I'm not saying that all judges do that, but sometimes you'll walk in the courtroom and especially if you've already received a case halfway through it, there's a judge who's already kind of got an opinion on the defendant or the plaintiff, and he's got an opinion on how this is going to go, and then you're up against a hard spot where you're already in an adversarial position, not only with the opposing party, but in some instances a little bit with the judge.
Yeah, absolutely. I mean, we're blessed in Atlanta and in Georgia as a whole to have a really, solid judiciary. Mm-hmm. But you got to keep in mind that judges have constraints, right? Mm-hmm. They have objectives and goals that they're trying to meet in their job. And one of those goals is to move cases. So they're looking for efficiency. They're looking for effectiveness. They're looking not to have your time or their time or the jury's time or the court's resources wasted or stretched out unnecessarily, right? And so certainly, yeah, they'll have a perspective on the case, and they'll generally be very balanced about that. Where the real issue is if you try and do everything, right? If you're not sure sort of the pros and the cons or what is worth focusing on, yeah, you can end up on the wrong side of the judge as well because you're worried too much about going to appeal when, there's almost no concern in their mind that you'll end up there.
And you can, and I know judges have standards and they're supposed to be objective, but I have seen it happen. Judges are human beings, and you can end up on the wrong side of that human being, whether he's a judge or just, Joe Blow down the street. It happens.
Absolutely.
Okay, so you see the in Hollywood, you always see these attorneys go off to the side, and I guess it's called a sidebar. How does that affect the record?
So the sidebar is tricky, right? Because it's literally off the record. That's the purpose of it, and it's usually removed from the jury. Most of the courtrooms in Georgia now are designed to have some sort of white noise or noise canceling system in place, so that the jury has a very difficult, if not impossible, time making out any sort of bit of the conversation that's going on between the attorneys and the judge in a sidebar. What's helpful about a sidebar is that it's off the record, so you can dispense with things, speak more informally, which helps you get to the heart of the issues and really can be used as a very strong tool for efficiency. I've got a few instances that come to mind where there's just a miscommunication between the parties and the attorneys are disputing, one issue that ultimately you ask for a sidebar, you go up to the judge, and it's handled in 5 seconds.
Excellent. So when we boil this down, if it's not on the record, it doesn't exist. Am I correct?
That's more true than it probably should be. The record really directs a lot of review, and basically the attorneys and the appellate judges are going to be bound by the record, right? Mm-hmm. Things that happen off record, generally are very difficult to establish as even having happened. Mm-hmm. Much less be something that can satisfy and support some sort of ruling or appellate change.
Mm-hmm. Now, what if the judge gives jury instructions that you just think are completely wrong? Is that reviewable?
Absolutely. Jury charges is a very big part of appellate review, right? Mm-hmm. Because the jury needs to be properly informed as to what they're doing, right? You hear all these metaphors about the difficulty of the modern juror and the jury in a court system, right? Mm-hmm. And it's a difficult thing to have these jurors come in and be told, don't go look up outside information. Mm-hmm. Don't pop up your phone and Google
this. Almost never happens.
Right? Like it's something that, I think the average juror probably does more often or violates more often than we would hope that they would, right? I've certainly... encountered people from other jurisdictions who've been who've done jury service and have confided in me that they Googled something or did something during the trial that that needs to be addressed. And when that happens, that's a problem for everyone involved. And so, but the juror doesn't see it that way, right? They look at it as, hey, I'm informing myself, I'm informing the decision, I'm helping to serve justice. And so there's that natural contradiction that you have to be very mindful of. And it gets, it also all comes to a head with the jury charge.
That makes sense. Now, it just because a juror actually has been, I'll call it tampered with, but has had some outside influence, that's not really appealable, is it?
It is if you can show it. Certainly, there are standard procedures that are in place. It seems like
there's difficulties with that.
Absolutely, right? Finding out about it, addressing it, showing that it's sufficient, to support some sort of issue or some sort of review. All of those are things that would need to be addressed sort of one by the other. Now, I haven't had to deal with that, as an attorney on a case. I've encountered that firsthand, but certainly, yeah, there are a number of issues there that just naturally derive from it.
Tricky. Okay, we're at the end of this segment. Francis, give them some contact information for you.
So again, Francis Dixon at Dixon Law, LLC. We specialize in last-minute litigation, trials, and appeals. My best contact number is probably Francis at DixonLaw.com, 678-214-7700. And again, the email is Francis, Francis, at DixonLaw.com.
You're listening to Lewis on the Law. I've got another great show geared at empowering you, the listener. If you'd like to get in touch with me, I handle real estate transactions and real estate litigation. You can go ahead and give me a call at 404-610-0075. Once again, that's 404-610-0075. You can also email me at james@jameslewislegal.com, or you can go to my website, jameslewislegal.com, and go to my contact page and hit me up on the last bit of my contact page. Once again, if you have a serious legal issue, don't rely on the information you hear on this show. This show is only designed to give you information. It's your first step in the legal process. If you don't know what type of issues to preserve, what type of attorney you're looking for, whether you have a case or not, you can actually go to my archives, and I have almost every single legal issue you can think of archived there. Eventually, I will have every single legal issue that you can ever imagine archived on my website. You can go there and find out what kind of attorney you're looking for, whether you have a case or not, or what you need to do. When we get back, we are going to talk about filing the appeal. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And I want to let you guys know that Lewis on the Law is now streaming nationally on every single national streaming platform that you can think of. We are even AI compatible. You can go, hey, Google, look up, or hey, Google, play Lewis on the Law, episode 48 with attorney Francis Dixon, and voila, you will hear my brilliant intro. I want to say it's brilliant because I wrote the music and played the music on it. I don't know if it's brilliant or not.
It's brilliant.
I think that bass is off. I listen to it every week, and I'm like, oh, that bass is a little bit off. I've got to re-record that. But I use one of these syncing programs that's supposed to sync everything up. And the modern music, I don't know if you play any instruments, but the modern music editing programs are, if you're singing out of key, you can do auto tune. It'll sync everything up for you, so everything's supposed to be perfectly in. So much for modern syncing. Doesn't always work out that way. Okay, let's get back into our conversation. All right. Okay. Filing the appeal, the appellate brief. I want to say appellate. I don't know why. I think it's just because apples are delicious.
Apples
but it's
are
the
delicious.
Appellate brief. Okay, tell us about it.
So generally what you're dealing with is an unfavorable verdict, right? You went to trial and you lost. And so then, there are usually a couple of standards, like you might file a motion for reconsideration. It varies depending on the type of case and then the court you're appealing from and whatnot. But yeah, generally you file what's called a notice of appeal. You let the court you are appealing to know that, hey, we will be appealing this judgment, and you do so within the time requirements at issue. And then, you start preparing a brief. There are really three different types of briefs that you're going to be dealing with in the appellate system, right? One's a merits brief, which is just straight up, hey, like these are the things that the trial court got wrong that need to be fixed. Then you've got your discretionary briefs, which is a brief, hey, you don't have to take this on appeal, but we think you should, and here's why we think you should, where you have to be a little more sensitive to the fact that the court has limited resources, right? And if it's a discretionary brief, it's generally a discretionary appeal, and they're not required to look at anything. So you want to be efficient, and you want to, lay out the issues quickly, cleanly, and sort of make the best argument in the most efficient manner you can. And then you got your amici briefs, right? You've got a party who is outside the case, who is sort of a friend of the court, who is filing to support a reversal or a reexamination of some issue for usually larger policy reasons as opposed to the record itself.
Interesting. So how much background research does it take? I mean, you've already gone through your case. You've done a lot of work here. How much more background research is really necessary to go ahead and move forward with an appeal to, say, the Supreme Court?
Well, I mean, it's a mistake to think that too much from the trial level extends out to the appellate level, right? It's a sort of a whole new ball game, right? The appellate courts have their own standards and their own rules and their own methods, and you basically have to start from square one. There is some
not on the facts, but just on statutes, legal research, your argument.
Exactly, and so that's where I was sort of getting to, is that there's some benefit to the fact that you don't have to go digging for new facts, but certainly now you're getting into a much more in-depth discussion of the law at issue and the procedures at issue, right? In trial court, generally a judge has pretty broad discretion, and you're focused on the facts for the most part, right? And applying those facts to the applicable standards of the law. When you're on appeal, it becomes a much deeper, much more intense look at the law and the procedure in place, and you have more time, right? If you're in the second day of trial and some issue crops up, you have a limited amount of time and a limited amount of resources to address that, right? If you are on appeal, you have months to dig into what happened in 5 seconds and was opened and resolved in 5 seconds in the trial court. You've got months to look at that and see if it was handled correctly. And so, research becomes very important. And you have to go into a lot of depth and into a lot of detail.
Yeah, you said something interesting there. You said procedure too. Are there procedural issues that can be brought up during the appeal?
Absolutely. If we're talking about jury charges, right? That's something that in my mind is something of a procedural issue, right? Were the proper instructions given to the jury, right? And certainly that's based in law, and the review is going to be a question of what the legal standard is and how previous jurisprudence has dealt with that. But, that's something that the court does routinely, right? It's something that gets, handled a certain way, and local rules generally dictate specifics for each court. And then you've got the law at issue. And so, there are a number of issues like that that crop up and basically exist in every trial as a matter of procedure.
Interesting. Now, sometimes you see those big charts and diagrams. Is that okay to bring into, say, the Georgia Supreme Court? I mean, can you bring visual aids in?
Absolutely. But generally, you want to, again, keep in mind with the fact that you are constrained, especially in oral argument on appeal, which I think we'll talk about in a little bit with more detail. You want to be very pointed. You want to be very effective with your visual aids. You don't want to be trying to draw the attention of the court to a visual that isn't absolutely necessary and very direct, because again, you have a very limited amount of time to go through your entire case, and really the time for things like that and arguments like that is going to be in your brief.
Okay, so you want to be to the point, definitely. You don't want to waste a lot of time, not have any wasted motion. It's kind of like Kung Fu. At least that's what I imagine Kung Fu is in the Kung Fu movies.
Absolutely.
No wasted motions.
Right, yeah, efficiency. On oral argument, what you're really doing is you are addressing any questions the court has regarding the argument you advanced in your brief and in your writings to the court. Right? The purpose of it is not to address the argument as a whole. It is to act as sort of a stopgap or a conversation about the arguments, so to make sure everybody's on the same page and sort of effectuate communication over the issues between the parties and whatnot.
Now, the Supreme Court, they've got a lot of information, but there is a ton of legal information out there. No one can be an expert in every single field. So, how big a role does statute? I mean, this is kind of playing on the research. How big a role does statutes and precedents set in an argument before the Supreme Court?
I mean, it certainly carries a lot. You say, no one can be an expert in everything, but there are certainly some justices on the Supreme Court that, at least for Georgia,
that know a lot about a lot.
Might prove you wrong.
Yeah. I guess I should check myself before.
Well, and my experience is very limited. Like I've done one appeal, so I'm not sure how comfortable I am in sort of extrapolating out from that. But yeah, in my experience, those play a big part, and they are the guiding light that the Supreme Court and really any appellate court is going to use to guide their decision making. Statutes, precedent. I mean, the activism of judges, right, is a constant issue in politics and in sort of the American
jurisprudence.
The spotlight that the citizen receives, right? How active can judges be in interpreting what the legislature puts into place? And certainly there are good arguments for both being more active and being less active. But at the end of the day, it's the law that the judges are there to enforce, and that I think is kind of their guiding light.
Okay. Now, sometimes you deal with situations that are not clean. Now, it's great when you have a case that's clean cut. Everything is on your side. The law is on your side. The facts on your side. But what about those dirty cases where, it could go this way, it could go that way. There's some bad facts that are negative to your side. There may be even case law that brings into question your side, but you have a strong argument on your side. What about those negative factors?
Well, and that's something.
Do you address those?
Absolutely.
Or you just kind of ignore them?
Address those. You bring them up. You bring them up to the court, and you're very clear about bad facts and bad cases. And I think there's a pretty strong duty in place that as an officer of the court, you have to make the court aware that, hey, there's this case that isn't in my favor, but here's why it doesn't quite fit the bill here. Right? That's the way that you address that. You don't try and hide anything from the court. You differentiate between what makes the other case a no, in your case a yes.
Okay.
Right? And that's our job as advocates, right? That's one of the aspects of being a good lawyer, is taking the situation and explaining why it isn't a lost cause, and explaining why there is some justice that's currently being left on the table that should be seized and should be granted to the party deserving of it.
Excellent. Okay, we're at the end of this segment. Once again, give them some contact information for you, Francis.
So again,
or can I call you Frank?
Yeah, absolutely. Frank, Francis. I had one guy in law school call me Franchise as a nickname.
Franchise, I like that.
So, but yeah, we're Dixon Law LLC. We focus on trials and appeals and specialize in courtroom work, right? And last minute litigation is sort of a niche that we uphold and we fill in the community that many other attorneys and law firms don't seek to fill. So that's when we usually get called in. We can be found in the Peachtree Center, and my email is Francis, FRANCIS @DixonLaw.com, DIXSONLAW.com. You can reach us by phone, 678-214-7700, and really even fax us in information if you need to at 678-214-7701.
Wow, fax! You are so fancy. I'm like, people will ask if they can fax me. I'm just like, nah, scan it and send it in an email. I don't do fax. You're listening to Lewis on the Law. My name is James Lewis. I am your host this week and every week. If you have a topic you'd like to hear on this show, go ahead and contact me at jameslewislegal.com. You can also just give me a phone call. I always answer phone calls. I'm happy to talk to people. You can give me a call at 404-610-0075. If you need an attorney, you don't want to listen to this show, you want to go ahead and hire an attorney. If you can't find an attorney, you can go ahead and contact me. And if I can't help you with your legal issue, a lot of attorneys come on my program. I'll direct you in the right way to go, who can actually help you with your issue. When we get back, we're going to talk about the oral argument. You are listening to Lewis on the Law. My name is James Lewis, and we are reaching for a higher ground right here on this show. We are talking about the Georgia Supreme Court and the process of appeals. I have attorney Francis Dixon on with me from the Dixon Law, or from Dixon Law. I want to say the Dixon Law Group or Dixon Law Firm, but it's just Dixon Law. It's short, clean, and simple, kind of like what that guy was saying about Facebook. Keep it clean.
Yeah.
You know, they wanted to call it I don't know if you saw the movie. And I don't know how true it is, but they wanted to call it the Facebook. And he was like, nah, Facebook. Keep it clean.
Yeah.
I like that. Dixon Law. Keep it clean. Mine kind of just rambles on. James Lewis legal, blah, blah, blah.
I like yours.
Yeah, it just kind of rambles on.
The alliteration's what really makes it work. James Lewis legal.
And then Lewis on
the
law. I kind of thought all that. And then I kind of thought of all the acronyms and how they'd be cool. So I was like, I'm 5 steps down the line on a big law firm and how you're going to market it. And you'll have all these cool little acronyms going on and sidebars. But who knows? Maybe that'll never happen. Who knows? Maybe it will. Maybe the whole thing will change before it's all said and done.
Well, for my part, I really like it. I think you're doing great.
Why, thanks, Francis. You're doing awesome, too. You're a good guy. Anyways, let's get into the meat of this subject, the oral argument. This is kind of where we are now.
Sure, yeah. And that's something we alluded to earlier, right? Mm-hmm. Was that's where eventually this leads, you know. And not every case, you know, needs an oral argument or really merits one. But certainly that's the time to go and have a very frank conversation about what's going on and the issues at play and the realities that might not be punctuated upon sufficiently by the written word, right? And, you know, I've heard different attorneys I've talked to, you know, in preparing my own appeal, I spoke to a lot of attorneys and did a lot of research on how these things go. And, you know, one thing that's a sort of a standard sentiment is that you will not really change the court's mind on oral argument, right? You're not really there to persuade them that they are completely wrong after reading your brief, right? The point for convincing them and for bringing them in and showing them what the case is about is with the brief, right? And I think, you know, my oral argument, there was an attorney who presented after me where Justice Namias pontificated on the importance of facts, right, in the brief, and how it has to be a marriage of both the legal argument the court should be looking at and the facts that they need to apply the law to with regard to the record and the proceeding and how the trial court operated and what they did. So
yeah, that's interesting that you brought up Justice Namias because his brother is a professor at Georgia State in the philosophy department. I don't know if you knew that, but I had some classes with him, and he was like, "Yeah, my brother is a Supreme Court justice," and I'm just like, "Oh, okay, cool." Yeah, so it's just interesting. Enough of that. Okay, so wait a minute. First, how long is this oral argument? How long does the whole thing? Do you just get to talk and talk and talk and talk until you like drown the justices with your incredible intellect and logical conclusions?
Right. Well, my oral argument was 20 minutes. I had 20 minutes that I could use, and I think I could reserve 5 for rebuttal. And it flew by. You know, it really goes by. You have 20 minutes to talk about, again, like we were talking about, how you can spend months researching 5 seconds that happened to the trial court, and you try and distill that all back down into a 20-minute conversation that's not one-on-one, but one on several, right? Because you're dealing with the whole bench. You know, it flies by. It really does.
And so you're dealing with the whole bench. Are they asking you questions? Are they grilling you on the topic and the issues?
Yeah, and you know, that's something we discuss from basically moot court on, right? Is how active the bench is or how hot it is, right? You're dealing with a cool bench where, and I think I saw this the same day that I had my oral argument, where someone's up there on oral argument and the judges don't ask a single question. The justices don't ask. They don't have any questions. They just let you go. And you can be dealing with the opposite, where they won't let you get an answer in to one question before they're already throwing 2 more at you. You know, based on my recollection, I got kind of one in the middle. I got questions where, you know, it seemed appropriate and where there were definitely things to discuss, but I didn't feel overburdened or like the bench was being really too in my face, so to speak, about it.
Interesting. So they didn't just grill you, like put you up on a spit and just grill you.
No, thankfully.
Right. Okay. So is public seating available? I mean, can the public come in and check this out?
I'm not sure.
Okay.
Generally, yeah. I would assume so.
Were there a lot of people there? I mean, were there just people there who weren't interested or who were on the side?
I'm really not sure of what the courtroom situation is. I think that it is very much open to the public and the people purveyors. I mean, certainly everything's posted online, so the arguments themselves are available to watch online. And I don't know whether that causes some sort of, sets the basis as a limitation for access to the courtroom or not.
So you didn't actually take a look around to see what's. I get it. So this is your first time in front of the Supreme Court. You didn't actually take a look around to see who's there and whether.
Oh no! I mean, certainly there were
Frank signs.
No, yeah, certainly there were clients' families and there were people there who were obviously not presenting attorneys. But I'm just saying that I'm not specifically aware of what the different standards are, whether it's, just show up if you want to come see what's going on.
Okay. Now you just said something about rebuttal. So you can actually, the other side goes ahead and delivers their argument and you actually get a rebuttal?
Right. So, the appellant goes up first and then the appellee responds. And so the appellant can reserve time to respond to the appellee's argument, right? Sort of just like you have in certain types of, legal matters. At the trial level, you have an opening or a closing, and the other side does their closing, and then whoever did the first close generally gets an opportunity to come back up and address what the other side said.
Okay. And so both sides don't just get their rebuttals and they just keep going on until they drown the court with their wit.
Nope.
Darn drat. Now, does the same process happen in the briefs too? I mean, you basically submit a brief, the other side submits a brief also, and then you reply. Is that still allowed
certainly
also?
you can file a reply brief. In a lot of situations, you shouldn't need to, right? Your first brief should be on point and efficient and effective is what we're shooting for. So you really shouldn't need to do too much. Your argument should speak for itself, and then the appellee's argument should speak for itself. And then, oral argument's a great place for addressing little mismatches or little conflicts in viewpoint. But yeah, there are definitely situations where even when you're trying to be efficient and effective with the court's resources, a reply brief is necessary.
Okay. Are transcripts available from these hearings? And if they are available, did you actually review other transcripts in cases similar to yours to actually help you a little bit, or was that just really a no-go?
No, yeah, absolutely. I reviewed transcripts from similar types of cases. Going through a list of everything I reviewed in preparing for this is something that we probably don't have time for on this show. But I spent several months working on just this case. They're pretty demanding. Again, because you have to scrutinize so much in such depth.
Sounds like a lot of research and background. So, are there special challenges with this with handling this type of case?
Absolutely, yeah. Certainly, every case is going to be different, right? And that's something that you have to really explain to clients. Something you'll see frequently, especially in our work with Lawyers for Equal Justice, is you'll have clients saying, "What do you mean research? Like, what? You're a lawyer, you've passed the bar. Don't you just know what you need to know for this?" And it's like, well, no, that's not really how it works, right? Every fact set's going to be unique, and then so the research has to be tailored to the facts, and you have to tie that together in a way that's unique to the case. So no two cases are going to be exactly the same.
But you're really lucky if you get a case whose fact patterns just lay out perfectly.
Yeah, absolutely. I mean, the stronger cases, like you were talking about earlier, right? Like dirty cases versus clean cases is, I think, the way you sort of matched it up. Yeah,
that's kind of the way I think of it in my head. I'm just like, oh, this case is clean. You've got a knockout punch early on.
Yeah, absolutely. And you'll find lawyers who specialize or prefer to take those clean cases, right? Because it's straight up, hey, like these facts are almost identical to the facts in case Y, where, 2 years ago, the court said, hey, boom, open and shut, done. And if you can match those facts on a 1-to-1 ratio, you should get the same result without too much effort. The dirtier cases where you've got good facts, bad facts, sort of vague facts all mixed in, in my mind, those are the ones that are fun, and those are the ones where lawyers really do make a difference.
Yeah, I think and even when I think of actually attorneys, because a lot of people think that when you say attorney, that every attorney is like Perry Mason and they walk into the courtroom and they're preparing for trial, but that's not true. Most attorneys actually don't want to go to trial or don't want to get stuck in the courtroom.
That's exactly right. And, if that was the case, I probably would have a different business strategy.
Yeah, exactly. You know what? I wanted to get into this a little bit more, but I see that we are just about out of time. So, Francis, thanks a lot for coming on the air with me. It was a great show. It was a great topic. Give them some contact information for you once again.
So, once again, we're Dixon Law, LLC, and you can reach me directly at Francis, FRANCIS, at DixonLaw.com, DIXSONLAW.com.
You're listening to Lewis on the Law. My name is James Lewis. I am your host this week and every week, bringing it to you to empower you, the listener. You can always get in touch with me at jameslewislegal.com. You can give me a call at 404-610-0075. I do offer free initial consultations. I know a lot of attorneys won't talk to you until you give them a retainer, but I don't actually do that. You can give me a call. I'm glad to talk to you about your issue, about your case. And maybe if I can't help you, I can steer you in the right direction. All my old shows are archived on my website. You can go to jameslewislegal.com. You can go ahead. I have a video blog page. I also have a podcast page. All my podcasts are also streaming online at every single national media platform. You're listening to Lewis on the Law. Oh, wait a minute. Before I leave, I have to thank the guys that make the magic happen. I've got our producer, Sam Davis, over here, making the dream, keeping the dream alive, and the wizard over there on video, Mr. Anthony Cook. I'll see you guys next week.